My name is Kyle Ingram and I represent employees in the Washington, D.C. area. And today I'd like to talk to you about the 3 keys to ADA accommodations. So what are ADA accommodations? Well, the ADA, the Americans with Disabilities Act, requires that employers provide employees who need an accommodation in order to be able to do their job with an accommodation. So a simple example of this would be a wheelchair-bound employee who needs a ramp in order to enter and leave the building where his job is. The ADA requires that the company provide such a ramp as long as it's not too costly. So the 3 keys that I want to talk to you about today, beyond the simple what is the ADA, is that the employer is required to go through an interactive process with you. At the end of that interactive process, however, the employer does not have to provide you with your preferred accommodation as long as it provides you with an accommodation that meets your needs. And finally, the requirement to provide an accommodation only applies if the employer can provide an accommodation. It must be possible to provide an accommodation that would allow you as a disabled employee to do your work. So what does it mean to go through an interactive process? The ADA requires that employees and employers sit down and discuss what the needs are of that employee. That means that the employee must say, well, this is my disability, and these are my restrictions because of that disability. The employee can also offer a reasonable accommodation, what he thinks would be reasonable. The employer must listen to all of that, and then must, if they can, provide a proposed reasonable accommodation to the employee. The employer then has participated in the process, and the employee is required, at least in most cases, to try out the proposed accommodation, and if it doesn't work, to come back to the table in the interactive process and say, I haven't been able to get this to work for me, can we try something else? That's essentially all that the interactive process requires, but both sides have to participate in it in good faith. And if they don't, that can be a problem. If the employer fails to participate in it on the employer's end, that means that there could be a violation of the ADA. The accommodation that you want may not be the one that the employer wants to give you. And if both of those accommodations would meet your needs, then the employer can choose which of those accommodations to provide, either its or your accommodations. The only requirement under the ADA is that the employer provide an accommodation, not a specific accommodation that the employee wants. This can be difficult for employees because the employer may not understand fully what their needs are. This is why the interactive process is important. The employee needs to go through the interactive process with the employer to let them know, hey, this isn't working for me. This was a good idea, maybe, but it's just not working, and this is why. And once the employer understands that, the employer is probably obligated at that point then to provide another accommodation and may choose to provide the accommodation that you wanted. But without that give and take, without that process, and without trying out accommodations, the simple fact that the employer does not provide an accommodation that the employee wants doesn't subject it to legal liability. It is not legally required to provide that. Finally, an accommodation must be possible. If you have a disability that cannot be accommodated for whatever reason, the ADA actually may not apply. The ADA applies to employees who have accommodations that the employer can accommodate. Where this most often comes up is in the context of whether or not the accommodation request is an undue burden on the employer. An undue burden is where the request is so costly or so disruptive to the employer that it simply is unreasonable for the employer to be required to provide that. There are very few kinds of requests for accommodations that are themselves an undue burden, but it can be a big sticking point, especially if the cost of the reasonable accommodation is slightly more than very minimal. If the employer has told you that the accommodation that you have requested constitutes an undue burden, it's probably a good idea to seek out some legal advice on that. The requirements of the law are not set in stone about what is required and what is not. Figuring out what is reasonable under the circumstances can be complicated, and it can require a lot of in-depth knowledge of what has been required by courts in the past in similar cases. Finally, if you have any questions about this at all, you really should seek out an attorney. Nothing that I've said here today is legal advice for you. If you think that you've been the victim of discrimination, or in this case, failure to provide a reasonable accommodation, which is a form of discrimination, you should consult with an attorney who can talk to you about the facts of your case. And many attorneys will talk to you for free or for a very low cost about what has happened and explore your options.